Hi, everybody. This is Carolyn Fahey. I'm the Executive Director of Arroic, and I'd like to welcome you all today to Arroc's webinar series. The topic we have to present for you today is the Arbitration and Litigation Overview. If you look at the slide 2 there, you can see the table of contents, kind of generally what we're going to cover today. I'm going to introduce you to our esteemed panel of presenters. I'm going to tell you a little bit about Arroic, and then we're going to move into more of the content by the overview of reinsurance disputes, a look at the arbitration versus litigation, what's similar and different with the two, a look at the stages of arbitration, post-arbitration considerations, and then we're also going to give you some resources if you want to learn more about arbitration on your own. As I said, I'm pleased to work with 3 presenters today. We have on the line Ed Diffin, who's a partner with Freeborn and Peters. He concentrates his practice in insurance and reinsurance arbitration and litigation. We also have with Freeborn and Peters Sean Keeley. He's a partner in their New York office, and he also focuses a lot on reinsurance litigation and arbitration. And then we also have Teresa Snyder, who's with Butler, Rubin, Saltarelli, and Boyd. She's in their Chicago office, and she also has a great concentration in the same area. I'm not going to read their bios. There's a PDF attached to the materials that you got, which really kind of will give you the overview of all their experience. I also have on the line with me today Bill Teich. He's with the Hartford and on the Arroic Board of Directors. And although he's not listed as a presenter, he's going to give us some commentary and thoughts as well. Now, first moving on to a little bit about Arroic. You can look at the mission and vision of Arroic there. A lot of the folks who are on the line probably know about Arroic or with companies who are Arroic members. We're pleased to have you here. One of the things I want to highlight a little bit is to promote our mission and vision, what it is that we do. We provide a lot of educational opportunities, such as this webinar, as well as a lot of in-person opportunities. And one of the things that our member companies rely on Arroic a lot for is to provide a forum so that they can do business, whether it be mergers and acquisitions, commutations. A lot of business deals happen at Arroic, and that's one of the things that brings really great value to the industry. You can go to our website, arroic.org, which is also listed on the closing screen of this, to find more information about our events, about the organization, and hopefully to attend some of those in person at some point in time. We also have our own designation, the Certified Legacy Insurance Professional. Just by attending this webinar today, you are taking a step toward qualifying for that. So take a look at it. If you're at the point in your career where you're interested in adding to some of your professional designations and interested in learning more about legacy, it's a great thing to do. The next slide just has a list of our members. You can see there's a lot of diversity there. Arroic has underwriting company members, reinsurers, what we call managing members who help manage blocks of legacy business. We also have brokers and liquidation bureaus as well as insurance departments. The folks who are on the line today and helping to present are all with law firms that are Arroic corporate partners, and we greatly also value their input, that they're able to provide a lot of really good resources for us education-wise and things like that. Okay, that's enough from me. You're certainly welcome to contact me in the future if you'd like to know more about Arroic. Just wanted to make sure for a disclaimer here, we need to read this to make sure that everybody understands that the opinions and thoughts expressed herein are the opinions of the authors, and it should be understood that the thoughts and insights are not necessarily those of Freeborn and Peters, Butler, Rubin, Saltarelli, and Boyd, or the Hartford. And with that, I'm going to turn it over to our first presenter, Teresa, who's going to take you through a little bit of the overview of the disputes in the industry.
Thank you. Before we talk more in detail about arbitration and litigation, I'm going to briefly outline some of the types of disputes that you see in the reinsurance industry. And because a reinsurance agreement is at its heart a contract, one of the main types of disputes is for breach of contract. So, for example, a cedent may argue that a reinsurer breached a contract by not paying claims or by challenging the amount of a claim. The reinsurer may contend that the cedent breached the contract by providing late notice and not complying with the notice provisions of the contract. There may be breach of contract claims for failing to comply with the business covered provisions of the agreement, and that can arise on a premium side or on a claim side. And reinsurers and cedents may have access to record disputes where one party is claiming that the other is not abiding by the provisions of the contract that enable audit and inspection rights. And if we turn to the next slide, there are other types of disputes beyond breach of contract that we see in the reinsurance industry. And these may include contract formation disputes, where one party alleges that the other party fraudulently induced them into entering into the contract by, for instance, misrepresenting what was going to be reinsured or the loss information relating to that book of business. In fraudulent inducement cases, one of the parties may seek rescission of the contract. So they want to unwind the entire deal and have the parties go back to as if they never entered into the contract in the first place. A variant of that is where one of the parties to the reinsurance agreement may seek reformation. They may claim that the contract does not actually reflect the party's bargain and should be reformed or changed in order to reflect what the parties actually agreed to. Other types of claims that arise in the reinsurance context are claims for fraud or for the breach of the duty of utmost good faith between the cedent and the reinsurer. And you could ask yourself, are there unique factors in the reinsurance industry that contribute to disputes? And if you turn to slide 9, we can see a few of those things that may contribute to disputes in the reinsurance context that don't exist in some other areas. First of all, a lot of disputes relate to very old contracts, and this means that witnesses are unavailable or documents cannot be located, and in those types of situations, there may be more difficulty in reaching a commercial agreement or settlement of that dispute because neither party has the evidence to back up their claims of how things should be interpreted, and so they need that third party to resolve the issue. The other factor that contributes to disputes that need to go to a formal resolution process is that when contracts are in runoff, there's no longer any premium being ceded, or when the parties are in runoff, there may no longer be an ongoing business relationship. The parties are then unable to resolve their differences by trading forward, either with respect to that particular contract or with respect to a new and different contract and business relationship. And another factor is the parties involved in a dispute may not be the original contracting parties. There might be a consolidation of business where someone new has taken over the contract, or there might have been a retrocessional agreement where the party whose interests are really involved is not one of the original contracting parties. And all of these things can lead to disputes that can't be resolved without going through a more formal process. And so, Ed, we've got a dispute. Where does it get resolved?
Thanks, Teresa. The first thing, or one of the first things to think about when you have a dispute is whether the dispute will be resolved in arbitration or whether it will be resolved in litigation in court. And the most important thing to consider in that regard is whether the contract at issue has an arbitration clause in it. Most treaties, reinsurance treaties, will have arbitration clauses. In contrast, facultative certificates are less likely to have arbitration clauses. Some do and some don't. If the contract in question does have an arbitration clause, you'll want to consider the scope of that clause and whether it covers the dispute that you are facing.
So, Ed, I have a question for you.
Sure.
I'm looking at it, and in a lot of our records, we're missing, say, the back page of a fact certificate, or maybe missing a potential arbitration clause in a treaty. How would we deal with that type of situation?
Well, arbitration is a creature of contract, so you need to have evidence that the parties have agreed to arbitration, or you're going to be in court. Now, if you can't find the arbitration clause, but both parties agree at that time that they would rather the dispute be resolved in arbitration, then you could agree at the time the dispute arises that it could be arbitrated. Otherwise, you would need to find evidence of some sort that the parties had agreed to arbitrate the dispute. If you can't find any evidence and the other party won't agree to arbitrate, then I think you're likely to end up having to go to court, unless you can prove in some way that yes, we had an agreement that this dispute should be arbitrated.
Thank you for that.
And if you're thinking about arbitration, you also need to think about the scope of the arbitration clause. In a lot of instances, the scope is very broad. It may cover, for example, any dispute, controversy, or claim arising out of or in connection with or relating to this agreement, or any breach or alleged breach hereof. That's a very broad language, a broad clause, and that's going to cover almost any dispute that relates to the parties' relationships. And that would be fairly typical, in my experience, to have a pretty broad arbitration clause. But occasionally you do come across a clause that is more narrow. For example, one that I encountered in the past said that it only applied to all disputes or differences arising out of the interpretation of the agreement. This clause was found not to apply to fraud allegations relating to the formation of the contract. So the fraud related to formation, that had to be litigated. It was not part of the arbitration clause. And again, as I mentioned a little earlier, the parties could agree at the time their dispute arose that they would like things to be arbitrated, even if the contract in question doesn't have a clause for arbitration. Beyond the scope of arbitration, arbitration clauses also have basics about the selection of a panel, the place of arbitration, and the panel's authority. For example, they might say that arbitration shall be conducted by a 3-person arbitration panel. The arbitrators and umpire shall be either present or former officers or directors of insurance or reinsurance companies. And then it will say things like whether the arbitrators need to follow the strict rule of law, or whether they don't need to follow the strict rule of law, whether they should consider things like custom and practice in the reinsurance industry in making their decision. So looking at the arbitration clause is really an important first step to giving you a framework for how the arbitration will proceed, assuming there is such a clause. And if not, like I said, you're likely to end up in court. Now turning to the next slide, this slide talks about the stages of the arbitration. And we're going to go through these all in a little bit more detail, but you can see them here. First would be factual legal investigation of the merits of the claim and any defenses. Next, an arbitration demand and response. Third would be constituting a panel. Fourth, a position statement, an organizational meeting, discovery, pre-hearing briefs, a hearing, an award, and then confirmation or vacatur. First, I want to talk a little bit about the factual or legal investigation of the merits of a claim and defenses. And as we go through these, we're also going to be contrasting them a little bit with what would happen were you in court in litigation. In both arbitration and litigation, you need to conduct a factual and legal review to understand the strengths and weaknesses of your case or your defenses and to ensure that the positions that you are taking are not frivolous. The terms of the arbitration clause will impact any legal review. If the panel is relieved from following the strict rule of law or instructed to interpret the contract as an honorable engagement or to look to custom and practice of the industry, you might reach a different conclusion about the merits of your case than you were if you were in litigation, where a court is going to have to apply the strict rule of law. Courts, for example, may care more about case law or statutes than an arbitration panel might, especially if the arbitration panel is supposed to be considering custom and practice in the industry. So once you have conducted your factual investigation, the next stage is the arbitration demand, and this is on page 12. The arbitration demand is used to start the process. It serves a similar role to a complaint in litigation. It identifies the parties, the reinsurance agreement, and the issues in dispute. But it's important to recognize that an arbitration demand is generally much less detailed than a complaint. A complaint in court can run hundreds of numbered paragraphs, setting forth all of the facts and the story that led to the dispute. In contrast, an arbitration demand can be as short as a single page or just a couple of paragraphs. And in my experience, typically they're no more than a handful of pages. The response to an arbitration demand is usually even less detailed than the demand. If the respondent wants to counter demand, it might include that information in its response, naming its arbitrator, but it's not required to do so. Again, this would be very different from how things would proceed in court. In court, the defendant needs to answer the complaint, and that involves admitting or denying each of the numbered paragraphs that were part of the original complaint. Again, assuming you don't move to dismiss the complaint in its entirety. Whereas a response to an arbitration demand is usually just a simple, we disagree and we name our arbitrator. Depending on the arbitration clause, the party demanding arbitration may need to name its arbitrator in the demand. In general, the demanding party will also demand that the respondent appoint their arbitrator to start the contractual clock running. And that is because most arbitration clauses give the party the right to name the arbitrator for the other party if the other party does not do so in a timely manner. This brings up something that's very important to keep in mind when you're thinking about arbitration demands, and that is what the arbitration clause says about naming arbitrators. If you have a certain amount of time to name your arbitrator, it's really important that you don't miss that deadline because if you do, then like I said, the other party is likely to be able to appoint somebody in your stead. If we go to the next slide, this talks about the constitution of the panel. Again, typically each party in reinsurance arbitrations would appoint an arbitrator, and then there would be a third person who acts as the umpire. When you're thinking about appointing your own arbitrator, typically you would meet with some potential candidates for your arbitrator, let them know a little bit about the dispute. It's important to recognize that they can't promise to vote for you, but you can get a general sense of how they might think about the facts as you know them and what their position is. After that, you would select the person that you want to name as party arbitrator. For umpire selection, usually the arbitration clause would contemplate the way that should happen. Typically, clauses say that the two-party appointed arbitrator should try to agree on the umpire. As you might suspect, that very rarely happens, but sometimes it does. But if it doesn't happen, then typically a arbitration clause would have a default selection method. It might say, for example, that if the two-party arbitrators can agree on an umpire, then each party names two candidates, the other side strikes two candidates, and then of the two remaining candidates, they're drawn by lots, which is usually done through the even or odd closing of the Dow Jones. More recent arbitration clauses have requirements to name more than just 3 candidates, or maybe to follow a striking and ranking process where you strike so many candidates and then you rank them, and then the person with the best ranking is the one selected. And of course, the parties can agree to vary the selection method in their agreements. So with some of the cases I've been involved with that have very old selection procedures, such as the name 2, strike 1, the parties have agreed that, hey, we want to go down a protocol approach instead, where you do ranking, et cetera, and we've adapted the contract to follow that. Now, absent that, you're going to be, if the parties can't agree, you're going to be stuck with the procedure that's in the contract that you have. One other thing to keep in mind is that usually the parties will agree to submit questionnaires to the umpire candidates. And this is to ensure that the candidates meet any contractual qualifications. So for example, if they have to be current or former officers or directors of reinsurance or insurance companies. You also want to be sure that they were willing to serve, that they don't have any conflicts, and to learn what prior or current relationships they have with the parties, counsel, the arbitrators, or the issues in the case. One last thing that I wanted to raise with respect to constitution of the panel, and that is that in some situations, the parties might agree to modify the contractual agreement to use a single arbitrator. This might be particularly done with smaller cases where the dollar value in dispute isn't as large. Since the parties have to pay their arbitrators, obviously if you have only one arbitrator that the parties can split the payment of, that's a lot cheaper than each party paying for their own party appointed plus splitting the cost of an umpire. And I wanted to highlight that the Arroic arbitration procedures has a specific procedure for selecting a single arbitrator should the parties choose to go down that road. And in the Arroic procedure, Arroic sends out questionnaires to randomly selected candidates, and then each party selects just over half of those candidates as acceptable, and that procedure leads to a result in which there will be at least one match between the parties. And if there's only one match, then that person is selected, and if there's not one match, that Arroic will draw lots to select that candidate. So again, that's just a procedure to keep in mind when you're in a case where the dollar value just might not be there to support having 3 arbitrators involved. When you're thinking about arbitrator appointment, moving on to slide 14, there are a number of considerations you want to keep in mind. One is the arbitrator's background, and that will vary depending on the type of case you're faced with. If it's a claims-related case, you might want somebody who's been in the claims area. If it's an underwriting dispute, you might want someone who is an underwriter. You may want an accountant or an actuary or potentially even a lawyer if it's a contract dispute. You also want to consider the amount of money at stake, the complexity, the timing. Some arbitrators are really busy, and finding somebody who has the time to set aside for the hearing in a timely manner can be difficult. And you want to consider prior experience with the arbitrator. And that will be both the company's prior experience, your counsel's prior experience, and in the connection of the umpire, what your party-appointed arbitrator's experience has been with the umpire. Different people's personalities can click sometimes or they can clash, and you obviously want to think about that. Somebody could be a great arbitrator, but they just might not have the right personality to fit in that particular dispute. Again, you'll want to consider the identity of your opponent and your opponent's counsel and what has been their experience with the candidates. And that will often come through in the umpire questionnaires. And depending on your role in the case, you may want someone who worked for a ceding company or a reinsurance company. So there's lots of factors to consider when you're thinking about arbitrator appointment. And this is one area that obviously greatly contrasts with court. In litigation in court, you're going to be assigned to a judge. A judge will likely know little about reinsurance. In some courts, like the Southern District of New York, that get more reinsurance disputes, the judge may know a little, but they're still never going to know as much as the umpire and arbitrator candidates who spent years and years working in the reinsurance industry. And of course, if you end up with a jury trial, you're likely to have a jury who knows nothing about reinsurance. So you're going to have to really explain things if you're in court in a way that you wouldn't were you in arbitration. And of course, in court, personal relationships just wouldn't play the same role that they would in a reinsurance arbitration. In the reinsurance world, it's a small community. People know each other. Arbitrators have the same companies come before them multiple times, the same lawyers multiple times. So people have a professional relationship in a way that's just not likely to happen when you are before a judge in court. So that is something to keep in mind. Now that we've got arbitrator appointment settled and you have an arbitration panel in place, Sean's going to take us through the various steps in the actual arbitration itself.
Thanks, Ed. And so you can see, starting at slide 15, we'll run through relatively briefly how you get from putting together your arbitration panel to getting a decision from them. And one of the first steps is the parties will submit position statements. And normally in advance of that, once you've selected your umpire, the umpire will send to counsel for the parties an agenda for what the umpire will want to cover at the organizational meeting, which will be the first meeting that the parties and counsel have with the arbitration panel. And the agenda will list the things that the arbitration panel would like counsel to cover at that first meeting, and will also request that they submit position statements. And those are usually instructed to be short submissions to apprise the panel of the facts and the issues and the claims and defenses from each side. Usually those will be requested about a week before the organizational meeting is set to occur. And it's important to emphasize that they really should be short submissions. Normally, panels in reinsurance arbitrations are not looking for elaborate legal briefs in advance of that first organizational meeting. The idea is simply to give the panel a frame of reference so that they'll have an idea of what the issues are in the case, so that when they're discussing with the parties and counsel how to manage the case, what sort of discovery might be appropriate, how long that period of discovery should be, the panel has in mind the positions of each of the parties on what's involved. And so if we turn to the next slide, we'll talk a little bit about that first meeting between the parties and the panel, the organizational meeting. Normally that will be scheduled somewhere within a month or two after the umpire has been selected. And it's important to understand that actually until that organizational meeting, you don't have a panel in place. The panel is actually not in place until it's accepted by the parties during that organizational meeting. And a predicate to accepting the panel is considering their disclosures. Ed mentioned earlier, as part of the process of trying to choose an umpire, normally questionnaires will be sent out. And the purpose of those questionnaires is to ensure that the umpire candidates have the necessary qualifications, if there are any, in the arbitration clause, to have a sense for what experience the candidates may have had with the issues, so that they can bring to bear some experience in deciding the issues, and also to identify conflicts. In advance of the organizational meeting, more and more I'm seeing that each of the party-appointed arbitrators will provide written disclosures to the parties to facilitate the meeting. But even if they don't, one of the first orders of business when the organizational meeting begins is that each of the proposed panel members will provide their disclosures. So normally the umpire will rely upon his or her questionnaire responses, but update those with any additional information with respect to potential conflicts since the questionnaire response was submitted. And then each of the party-appointed arbitrators will identify potential conflict issues as part of their disclosures. And I should say the baseline is that normally there are not conflicts, but the idea of the disclosures is so that any relationship that any of the arbitrators has with any of the counsel or with the parties is disclosed, so everyone can make an informed decision to accept the panel. Once those disclosures are made and counsel has an opportunity to ask questions about them, the umpire will ask whether the panel is acceptable to the parties. And once each of the parties confirms that the panel is acceptable, then you have an arbitration panel in place, and that panel is authorized to conduct the proceedings and to make the decision on the issues presented to it. Normally, immediately after acceptance of the panel will ask for hold harmless agreements from each of the parties. There are standard forms for those available, for example, from Arroic, but they can also be drafted bespoke depending upon the requests of the panel members. But really, they're intended to hold the panel harmless from any potential claims by the parties or counsel for the panel carrying out their duties as part of the arbitration. Normally carved out from that is the ability for either party to seek to vacate a panel award at the end of the proceedings, but the panel members will not have any personal liability for carrying out their duties. Normally, as part of the organizational meeting, the panel will inquire whether the parties want to enter into a confidentiality agreement. In reinsurance arbitrations, confidentiality is the norm, although, as Ed stated earlier, arbitration is really an agreement of contract. And so, on occasion, the reinsurance contract may say something about confidentiality. If it does not, then that issue will be addressed at the organizational meeting. And ultimately, I think the majority view is that an arbitration panel that has been appropriately impaneled to handle the dispute can address issues such as confidentiality as part of their management of the proceedings. But usually a form of confidentiality agreement will be drafted and agreed by the parties and signed at the organizational meeting. And these are things that will be identified usually in the agenda sent out by the umpire in advance of the meeting so that counsel can confer in advance on acceptable forms. Another issue addressed at the organizational meeting is that of ex parte communications, meaning communications that a party can have solely with its own party-appointed arbitrator and not with other members of the panel. This is, while not a unique, a somewhat different aspect to reinsurance arbitrations than to some other commercial arbitrations. Many commercial arbitrations and international arbitrations will operate on the presumption that all of the arbitrators, all three arbitrators on the tribunal will be neutral and that there will be no ex parte communications once the proceedings begin. For the most part in reinsurance arbitrations, ex parte communications are permitted with the party-appointed arbitrators, but of course never with the umpire in the middle chair. But it's important as part of the organizational meeting to set the guidelines, the agreed guidelines among the parties and the panel as to when ex parte communications will be permitted and when they will cease. And so normally ex parte communications will be agreed among the parties in the panel to run through the proceedings and through discovery up until submission of the first pre-hearing briefs before the final hearing on the merits, although a different cutoff period can be agreed as well. If there are going to be interim motions on discovery issues, for example, in the course of the proceeding, the parties will also, at the organizational meeting, want to agree on a protocol for when ex parte communications will cease with respect to the issues raised in the motion. So, for example, I've frequently seen it agreed that ex parte communications on the issue in the motion can continue during the briefing, but as soon as the final brief is submitted, then ex parte communications go dark on that issue until the panel has issued a decision on the motion. Turning to the next slide, scheduling is also addressed at the organizational meeting, and that's usually a large part of what the meeting addresses. So often, after getting a sense for what the scope of the issues are, how many issues there are, the complexity of them, the parties and the panel will be able to have a good idea about how long it may take for the parties to prepare the issues to present at a final hearing. And based on that length of time, everyone will try to find in their calendars time for a hearing. Could be 6 months out, 9 months out, a year out, whatever is appropriate to the dispute. And also the length of the hearing. I've seen hearings run anywhere from a single day to a couple of days to multi-week hearings. Again, this is entirely a creature of what the dispute will require. That scheduling will also discuss in broad strokes what types of discovery the parties think they will need, because that will give a sense for how long that will take. And then also usually a brief discussion about briefing. What types of briefs, what number of briefs in advance of the final hearing would be appropriate for the dispute. And normally what will be done is at the organizational meeting, everyone will settle on the date for the final hearing and the length of it, and then counsel will be instructed to develop a detailed schedule for discovery leading up to that final hearing. Usually, more and more, the best practice is that schedule will also include frequent dates for the parties to report to the panel on the status of things to make sure everything is on track for that final hearing. As part of the organizational meeting, normally a protocol for interim disputes will be agreed. I mentioned there'll be discussion about ex parte with respect to interim disputes, but usually a protocol for the timing of briefing of such disputes is also addressed, so that at least there's a baseline subject to agreement as disputes come up, or altering the protocol. And then occasionally there are other issues raised at the organizational meeting. It's not the place to decide issues on the merits, but there could be issues prior to the final decision on the merits that need to be addressed. For example, not infrequently, one party or the other, usually the seating company, may ask for security for an ultimate award. If either the contract provides for security or they think there's some statutory basis for providing security. But there may also be other issues that are ripe to be presented at that first meeting. If, for example, the parties know there's going to be an immediate need for certain types of discovery, and the panel's aid may be necessary for that. But once you've completed the organizational meeting and ready to launch into preparing the case, you move on to discovery. And so on slide 18, I'll talk a little bit about discovery for documents. Normally in reinsurance arbitrations these days, it's standard as one of the first things to do in discovery is to exchange written document requests and responses. Often that is to be done within the first month or two after the organizational meeting in order to get things underway. And the idea there is to identify responsive documents, meaning documents that will relate to the issues in dispute and will help the parties to frame those issues. That can include both paper files as well as electronic files. The electronic files that will be searched will usually include emails. More and more reinsurance arbitration, given the nature of the disputes, and some of the disputes can be very complex, there's more and more electronic discovery to be done. And I find that arbitration panels are more and more savvy now in terms of addressing those electronic discovery issues. But there is a tension there because obviously we all know there's all sorts of electronic data out there that could be searched, but one of the things, one of the virtues that there should be in arbitration is that it can be a more streamlined, more cost-effective process. And so it's incumbent on the panel to decide how much of that type of discovery is appropriate to the dispute itself.
Hey, Sean, just really quick, to that point, and because I think everybody is aware of how burdensome electronic files, et cetera, can be. I mean, how does that usually work in arbitration? I mean, as far as a little bit more detail on limited discovery, let's say, or something. Could you expand on that a little?
Sure. So I think that's it is correct for the most part that parties recognize that arbitration should not be litigation, although there is more and more litigation creep in discovery. But for example, in the federal courts nowadays, and more in commercial parts of state courts, there are detailed rules on electronic discovery, and so the baseline will be that there will be such discovery, that the parties will agree on search terms to run across various databases. That, in my experience, is not the baseline for reinsurance arbitration. I think most panels will take the view that if both parties want that, then certainly they can have at it. But if there's not agreement on the scope of electronic discovery, I think panels generally do a good job in terms of trying to understand what is the utility of this discovery, why is it really necessary, and how will it actually help the panel to get to an efficient resolution. And so I would expect that there would be limitations in terms of the searching of backup tapes, for example, in terms of the number of custodians of emails, so that I think an arbitration panel is probably more sensitive in the first instance to limiting that type of discovery than is a court. But that being said, again, this is very much a creature of the parties' agreement, and so there are disputes where, given the amounts at issue and the complexity, that type of discovery is appropriate. And with most any discovery, be it just a few paper files or vast electronic discovery, normally the parties will still address the issue of privilege. And so, generally speaking, for any privileged documents that either party intends to withhold based on privilege, logs will be prepared. Again, there can be agreement among the parties as to what those logs will cover, and ultimately, if the panel needs to get involved with that, it can be addressed with the panel. The last point we've got on this slide is interrogatories. Interrogatories, as everyone may know, are tools that are used in litigation for the parties to put written questions to each other that need to be responded to and often verified under oath. In my experience, interrogatories are less useful in arbitration and less used in arbitration. The idea being that again, it should be a more efficient procedure, and particularly because these days depositions are a usual feature of arbitration, it's usually thought to be more efficient to do document discovery and then put any questions to the relevant witnesses rather than have that interim step of interrogatories, although again, that can of course be agreed by the parties. And so then moving on to depositions. Depositions are, in one sense, a bit of an odd animal for arbitration if the idea is that it's to be streamlined. In other legal systems, for example, in England, depositions are not a feature even of litigation. But these days in reinsurance arbitration, depositions are pretty much the norm, and usually they will be scheduled for some time within 6 months after the organizational meeting. Normally the schedule agreed by the parties will have a few months of document discovery, and once that document discovery is complete and everyone has the basis for identifying witnesses and for having a sense for what types of questions will be needed to be put to them, the depositions will be scheduled. Early on in the schedule, the parties will normally identify witnesses on their own side who have knowledge of the issues in dispute and whom they think they might call at the final hearing. And normally all of those people identified will be deponents. But as well, once each party has reviewed the documents produced by the other, they can request additional deponents. And as with everything in arbitration, the number of deponents will be something that will be either agreed, or if it can't be agreed, will be addressed with the panel. And again, those decisions usually should be made in the context of what's the complexity of the dispute, what's the amount in dispute, and whether these depositions are really needed to reach an efficient resolution of the dispute. And to do that, you've got to think about what are the purposes of depositions, and we've got that on slide 20. Obviously, you want to determine facts. There's not There are some facts that you won't be able to glean from documents alone. You also want to obtain admissions from the other side on certain issues that they viewed a point in one way or another, or that they have, at least on one aspect of the case, agreed with you. Depositions will be used to flesh out positions. So, and that's again, I mentioned the difference between English litigation and what we do here in the U.S. We use depositions in large part not just to ask the questions that we already know answers to or the answers we want to hear, but to try to flesh out, what are the facts, what are the potential positions that the other party is taking on things, so that we have a full understanding of that in order to present it to the arbitrators at the final hearing. And then also to test theory. It may be that we think we understand the way the other party is approaching an issue, but to test that, you really need to speak to the decision makers who will be the witnesses. One point to make on depositions is that most of what we've been discussing, I've been referring to the other party's witnesses, but there are situations where you may want testimony from non-parties, for example, a broker who was involved in the deal, or someone else who is unrelated to the contract, not a party to the contract, but has relevant information. It is considerably more difficult in arbitration to obtain that type of non-party discovery than it is in litigation if you have an unwilling non-party. There are mechanisms under the Federal Arbitration Act that in some parts of the country, in some federal courts, can be used as an aid to try to obtain evidence from non-parties. So, for example, you can try to obtain from your panel a subpoena for a non-party, but whether or not you'll be able to enforce that subpoena and compel the non-party to appear and provide evidence will depend in large part on where you are located and whether the federal courts in that district or within that federal circuit whether they will enforce that subpoena and under what circumstances they will enforce the subpoena. There is actually a split among circuits in terms of whether and how those types of subpoenas can be enforced. For example, in some places, if you can enforce it, it can only be done if it's done at a hearing. So sometimes the arbitrators, in order to take testimony from a non-party witness, will schedule an interim hearing where all three of the arbitrators or one of them will sit as the witness comes in and is sworn to and testifies. So that evidence is taken in the context of quote-unquote a hearing, even though it's prior to the final hearing on the merits. And then flipping to the next slide, speak briefly about experts. Normally there'll be discussion at that organizational meeting as to whether the parties think that expert evidence will be helpful in the context of the dispute, and if so, then expert discovery will be built into the schedule that the parties agree on. Again, this is entirely a product of agreement by the parties or a procedure that the panel will put in place if there's a dispute, but it can involve the initial identification of the experts. It can involve providing a report from the expert, although it need not. Normally, any documents that are provided to an expert who's going to testify will be discoverable, because each party is entitled to know the basis on which an expert is basing his or her opinions. And then if there is an expert report, there can be a rebuttal report prepared by an expert retained to address the issues in the initial expert's report. And then normally, if there have been depositions agreed as part of the process for fact witnesses, there will be expert depositions as well. But again, that's something entirely agreed upon by the parties or ordered by the panel in the absence of agreement. And one thing to keep in mind with experts is part of the idea of reinsurance arbitration is that the panel are experts in a certain sense, at least on aspects of the industry, at least have an idea for the industry. So you'll want to give thought, and the panel will want to give thought as to whether an issue really lends itself to evidence from an outside expert, whether it's something that's outside the ken of the arbitrators themselves and can really add value, again, with the idea of trying to maintain an efficient proceeding to get to a final decision. And so once you've gotten through that discovery and you want to get to the final decision, Ed, why don't you tell us what some of the next steps are?
Sure. Turning now, titled Summary Judgment. One option for resolving disputes before the hearing is to file a motion for summary judgment. Summary judgment is a procedure where a court or arbitration panel decides the case before the hearing or trial. And it happens where there's no disputed issues of material fact between the parties that require a trial, and where the law can be applied to the undisputed facts and one party is clearly entitled to win. Typically, with summary judgment, parties will file briefs in support of summary judgment, and the other party would file opposition briefs. And there might be oral argument by the lawyers, but there would be no witnesses who are involved to provide testimony. Summary judgment motions, they're very common in court. However, they're fairly rare in arbitration. They can be used, and it does save time and expense of the hearing. For example, they might be used where the dispute is just a dispute over contractual language. Everyone agrees that the contractual language applies, and it's just a matter of what the contract means. That could be a case where live witness testimony at a hearing might not be necessary, so you might file a motion for summary judgment. That said, in my experience, summary judgment is also rarely granted in arbitration. Arbitrators seem to typically prefer to have a hearing with live witnesses if there's any issues where they really think the live witness testimony is at all useful. It's also important to recognize that arbitrators, they're not required to follow the same summary judgment standards that a judge would use with summary judgment in court. In my opinion, arbitration, there needs to be a special case for summary judgment. Otherwise, the parties will spend a lot of time and money preparing the summary judgment briefs only to have summary judgment denied and to end up needing to go to the hearing anyway. So just think strategically if you're considering filing summary judgment in any case. Assuming there's not summary judgment, the next slide talks about pre-hearing briefs. In arbitration, the parties typically would submit simultaneous opening pre-hearing briefs and then simultaneous reply briefs to frame the disputes before the hearing. In these briefs, they would present arguments regarding points of law and key facts. They would attach supporting exhibits and deposition excerpts. And the panels typically would require submission of the entire deposition transcript so that they could read it all if they wanted to, even if you're only citing to certain portions of that transcript. Pre-hearing briefs are typically quite lengthy, very detailed. They really set out the party's case pretty fully. And this would be a contrast to court. In a litigation proceeding, you would not submit a pre-hearing or pre-trial brief that goes on for tens of pages. Sometimes these briefs can be as long as 100 pages or more even. You wouldn't typically do that in court. So that's a somewhat unique procedure as part of the arbitration process. Going to the next slide, pre-hearing disclosures would be also a procedure that you would follow before you get to the arbitration hearing. And this would involve identification of any exhibits that you intend to use at the hearing. And you would also identify any witnesses who intend to testify. If there's a witness who's not going to show up at the hearing, but they were deposed, you may designate portions of their deposition for the panel to consider in connection with the hearing. The pre-hearing disclosure process in arbitration is quite a bit different from what you would do in court in connection with the litigation. In court, one of the big things that is involved particularly with the jury trial, would be jury instructions and any objections to jury instructions. That would obviously not be taking place in an arbitration pre-hearing disclosure. Also in court, admissibility of evidence and testimony is a very big deal. And so therefore, a lot of the pretrial order is spent on objections to a party's exhibits based on hearsay or other admissibility objections. That is somewhat unusual in an arbitration. You can object to exhibits, but typically in my experience, panel members are willing to let most evidence that the parties want to present in and then say, we understand and we'll take it for what it's worth. But the rules of evidence are much less strict in arbitration, so therefore the pre-hearing disclosures are often a bit different. Now that we've covered pre-hearing disclosures, I'm going to turn it over to Teresa, and she's going to talk further about the arbitration hearing itself.
Thanks, Ed. So we're now at the evidentiary hearing stage of the arbitration, and this is typically an opportunity for the panel to update any disclosures that they have about their contacts with the parties. They may have connections with the witnesses that the parties don't know about, and the panel will disclose to make sure that following the hearing and an award, no one can claim that a panel member was biased because they failed to disclose some sort of relationship that they had that someone could conclude might impact their decision. So typically, panel members do provide those updates as developments occur throughout an arbitration, but oftentimes at the very beginning of the evidentiary hearing, the panel will just make sure that all of their disclosures are updated so that the hearing can't be overturned on any kind of arbitrator partiality basis. The hearing then will start with opening statements from the attorneys where each party will set forth what they anticipate the evidence will show. And parties are usually able to reach agreement on the time limit for those opening statements. Usually the more complex a case, the longer the opening statements will be. But the opening statements need to be commensurate with the length of time the hearing is going to take in its totality. So you wouldn't expect a one-day hearing to have very lengthy opening statements, while a month-long hearing may have opening statements that go to 3 or 4 hours apiece. After opening statements, the panel will then hear testimony from the witnesses. And generally, the petitioner will put on its case first, followed by the respondent in the arbitration. But depending on the issues involved and availability of witnesses, the order of witnesses may differ. And of course, again, since arbitration is a matter of contract, the parties can reach a different agreement on what the usual scenario would be. And in an arbitration, the witnesses who appear are sworn in just as though they are testifying in court. Direct examination will take place, followed by cross-examination. The party who called the witness in their case will usually have the opportunity to redirect the witness after cross-examination, and then the other side the opportunity to recross, limited to the redirect topics. One feature of arbitration that's somewhat different than court is that the panel members may ask questions of the witness. And although a judge can do that, and although the judge may permit jury members to submit questions to the court, who will then decide whether or not to ask those questions, arbitrators typically do take advantage of the opportunity to ask questions they may have of a witness. Usually they'll wait till the end after the attorneys have finished their examination of that witness. But if a point comes up that an arbitrator believes requires some clarification, they are free to interject during the attorney's examination in order to get that clarification while it's in the front of the mind. As Ed mentioned, instead of calling a witness to testify at the hearing, the parties may agree to forego doing so and instead designate portions of the witness's deposition as evidence for the panel to consider. And finally, most witnesses who appear at arbitration hearings are there on a voluntary basis because of the difficulty of the subpoena process to get a witness who doesn't want to appear. After all of the evidence is in, the witness testimony, the documents, the deposition designations, the attorneys will have their closing arguments. And so there is where the attorneys argue about the legal impact of the evidence and about what the evidence actually shows. At the end of closing arguments, the panel may have questions for the attorneys and seek clarification or additional information from the attorneys about what they are actually arguing.
Yeah, sorry, Teresa. It's Carolyn. Just one quick question for you, and maybe if you finish the thought if you need to there. But, it sounds to me like a lot of this sounds very similar to what we would I'd call a traditional litigation process. So if you could just kind of highlight what you see as the one main difference between the arbitration process and the litigation process, or an arbitration hearing and a court hearing.
The main difference is going to be the level of formality and application of the rules of evidence. And so while in court you're going to be in a very formal proceeding where evidentiary rules limit what evidence you can get admitted into the record, what types of questions you can ask the witness. Hearsay is the main thing that's very circumscribed in court as to whether a witness can testify about what they've heard from someone else as opposed to what they themselves have experienced or perceived. And in most arbitrations, the arbitrators are relieved from the strict rules of evidence, and so you don't have to establish an evidentiary foundation for a document to be admitted into the record. And you can have much more leeway in terms of what you can ask the witnesses to testify about and what they can testify about. And so in some sense, it's a more fulsome record that you're creating because you are not limited by evidentiary rules. But in another sense, those evidentiary rules exist for a reason in order to enhance the credibility of the evidence that's going to be considered. So you have those competing considerations, and the arbitration process tends to go with the less formal, I want to hear as much as I can and I'll take it for what it's worth, whereas particularly in a jury trial, the judge is not going to permit certain evidence in. The types of questions that the panel may ask of the attorneys and witnesses, again, are not going to be confined by the rules of evidence and by attempting to maintain the decorum of the courtroom. I've sometimes seen arbitrators get very worked up about what evidence has been presented to them, and they're very interested in questioning the witness and would go far beyond what a court would do in that connection. So if we turn to slide 26, what happens once that hearing concludes and the panel members have asked all of the questions they have? How do we get from there to a decision? Well, obviously the panel has to deliberate and try to reach consensus. one of the things that panels do in order to assist their deliberations is to ask the parties to prepare draft awards. And by obtaining draft awards from the parties, the panel can be sure that they know all of the relief that a party wants and that they address each of those requests for relief. It also helps give the panelists a head start on preparing the award itself. The panel members may deliberate in person immediately after the hearing. They may deliberate by phone. They may engage in email deliberations. They may, plan to get back together, some set period of time after the hearing takes place when they have availability in their schedules. And they may need to get together several times, depending on the complexity of the dispute and the differences of opinion about what the evidence shows in order to reach a decision. It's rare, but occasionally panel members ask for post-hearing briefs to cover a particular issue. The other unusual thing about reinsurance arbitrations is that typically the awards are very brief, and they basically set out the panel's decision and the relief that's being denied or permitted. And parties may want more than that, and the panel will ask if they want a reasoned award. Now, that's not to say every other award that's issued isn't reasoned, but in the kind of reinsurance arbitration parlance, a reasoned award is one where the panel sets forth the reasons why it's ruling the way it is, where there's an explanation of what they thought was compelling and what the evidence showed. Now, if you were at an arbitration in England, as opposed to the United States, a reasoned award is the typical way in which an award is presented. But in the U.S., awards are typically very, very brief. It's possible for one of the arbitrators or the umpire to dissent from a majority decision. And in those cases, the person dissenting may also write a short dissent explaining the reasons why they do not agree with the majority. Turning to slide 27, after the award is issued, the parties will decide if they want to initiate any post-award legal proceedings. So this is a time when the parties can think about, one, do I want to go back to the arbitrators to ask for clarification? Or two, do I need to go to court? And I can go to court to either confirm the award or to seek to vacate the award. And the party who won may want to confirm the award so that they have a court-ordered judgment that they can enforce. And this might be useful in situations where you're not sure whether the party that lost is going to pay, and you may have to try to attach their assets. And so there are certain benefits you get from a court judgment that you might not have from just having the arbitration award. The problem with obtaining a court judgment is that you may relinquish some of that confidentiality that you worked so hard to achieve by going to arbitration in the first place. And whether you're able to file your court petition under seal is going to depend on what court you're in and whether they have taken a view that court filings are presumptively public as opposed to permitting people to file their papers under seal. And so that's something you really need to consider in the context of going to court, is what is going to be the impact on the confidentiality that you've agreed to with the other side, that the panel has ordered, but that the court might not respect. If you're the losing side, you may want to seek to vacate the award. And In this context, you need to understand that it is very difficult to vacate an arbitration award. There are very limited grounds for vacating an award. It's not an appeal, and so the court will not be looking at whether the panel got it right. Usually, they're only looking at, did the panel act within the authority that it was granted? And the limited grounds for overturning an arbitration award are generally contained in the statutes that apply to arbitration, such as the Federal Arbitration Act, state statutes on arbitration, or if you are in a dispute with a company from another country, there might be an international convention on arbitration that applies to your agreement. But in all these circumstances, the grounds for overturning arbitration awards are limited to such things as fraud, evident partiality. So this is where one of the arbitrators or the umpire had an undisclosed bias that is very serious. The court may overturn the award then, or if there was misconduct in the hearing, such as where the panel refused for good reason to grant an extension of the hearing date, or whether it refused to permit evidence that it should have allowed in. And then, again, since arbitration is a matter of contract, if the arbitrators exceeded the authority that the parties gave to them, the award can also be vacated in that circumstance. So I'm now going to turn it over to Bill to address some practical considerations that arise in the aftermath of an award.
Thank you. So as we move to slide 28, in the aftermath, you may think that once a matter has gone through the decision and you have an award, it's over, but that isn't always the case. In my experience and the experience of others that I've spoken with, some decisions are not clear as to what was really intended by the panel, and at that point you may have to go back to the panel to seek a clarification, or you may want to seek a clarification between the parties rather than going back to the panel, but you have to be able to take whatever actions are required as part of the decision, and sometimes that takes extra steps. Also, partial decisions can be complicated, so it may be a finding that you owe a portion of the prior billed amounts and you owe a different amount on ongoing amounts, and how you're able to calculate that with manual calculations and practices, it takes it out of your mainstream processing. And it also raises a challenge as to documentation and training. Many of these treaties will be standing for another 20 to 40 years or maybe longer. So you have to be able to share that information and capture it so that people in the future will be able to bill appropriately. I've heard people have concerns with how to credit recoveries, fees and interest, and how that might impact the retros who may have already paid on a loss. So it's not necessarily an easy thing to do, and it can be challenging. You can also find yourself in a situation where you have different outcomes for different parties to the same contract. So, for example, if you have a grouping clause that's being disputed, you may have one outcome where a party is paid 100% and another is paid 85%. So once again, that leads you to manual processes and procedures and takes us outside of the normal operation. It also leads to great confusion with the brokers. Brokers generally like to see that a proof matches with the payments that are coming in. So if you're paying a billing at, say, 85%, the brokers may well reject that and force you to have to work directly between the parties and not use the broker, which could challenge your resources. Another potential is that you have a final determination which takes care of an issue, but then the next day a brand new claim comes in with the same issues. Then you have to consider whether the panel award deals with that, or do you go back to the parties to try to put an agreement together to follow the prior awards and how you best use that type of thing? Or do you have to have a second arbitration to, again, go all the same issues that you've done in the past? And another outcome that I've seen is documentation requirements as part of a arbitration award. So perhaps you have to provide more detailed reports or more information, and that can, again, cause strains on your resources and your ability to comply with the outcome of the awards. In the end, though, a lot of these types of things, which takes the process out of the routine and makes it more challenging, often leads itself to commutation. So I think in the end, that may be a positive outcome. But really, each decision has to be reviewed on its own to determine the factors and how it can properly be implemented. And each one will always present different challenges. Now, with that, we're moving to slide 29 and arbitration resources. So if you find yourself in an arbitration, you're not alone. You can see we have listed here Arroic Dispute Resolution Procedure, the Reinsurance Associated of America, Arias, and JAMS, and we have hot links for each of these. So again, if you find yourself in a situation where you're in an arbitration and you need additional resources, please refer to these areas for some very helpful and valuable information to get you through the process. With that, I believe we're moving on to the questions section.
Correct, and thanks so much, Bill. I just want to take a minute to thank all of our panelists today. I think this was a really great overview and gives our listeners a chance to really think about how arbitration is different than litigation. So with that, I want to thank Ed, Sean, Teresa, and Bill, and we look forward to seeing you in the future at an Arroic event, and let us know what you think of this seminar. Thank you.